Hello and welcome to Rights and Recourse, a program that tackles constitutional, human rights and legal issues, bringing you information and analysis. My name is Dumila Matez. Remember, you can also be part of our discussion today by tweeting us at Rights Recourse or calling our studio line on 011 714 5497 or 5498. Alternatively, email your thoughts to rightsandrecourse at sabc.co.za. In its 20th anniversary, the Commission for Conciliation, Mediation and Arbitration has reached a few milestones and set precedents. It had evolved from political resistance by the black opposition organizations and the new independent labor unions that increased in the 1970s, particularly after a wave of worker strikes. The government of the day realized that workers' unions had a staying power and could not be crossed. As a result, it set the two commissions in 1997. The Recourse and the Vian Commission. The formation of COSATU in 1985 convinced industry and government to regularize workers' unions, and at the dawn of democracy, the democratically elected government established the CCMA. Today on Rights and Recourse, we examine the road traversed by this statutory body aimed at conciliation and mediation at the workplace. To discuss today's topic, we are joined in the studio by Mr. Cameron Murajane, National Director from the CCMA, Mr. Patrick Deal, Labour Lawyer from Deal Attorneys, and Mr. Narius Moloto, General Secretary of the National Council for Trade Unions. Gentlemen, good afternoon and welcome to Rights and Recourse.
Good afternoon. Good afternoon.
But I don't know, I'm not making this question to a reference to anybody, but what I want you to answer, what is the difference between conciliation, mediation, and arbitration?
Perhaps can I have a kick-off on that, Emily? Conciliation is very much like mediation. It's really effectively, it's a supervised negotiation between two parties to a dispute. And the idea is for the conciliator to listen to the views of the one party and the other party and to find where there's common ground and to help them to reach an outcome that they are happy with and they can sign off in an agreement on to settle it. A mediation is much the same thing, but it implies slightly more vigorous intervention by the mediator, who gets more involved in the process. It's a question of degree, so there's not a big difference between the two. And then arbitration is different because that is like a judge. That's a person who listens to the story on one side, listens to the other story, listens to arguments about the law and makes finding of facts and law, and then makes an award, which is the equivalent of a judgment which has been then binding on both parties. So it makes a final, well, not a final judgment, but it makes a judgment, unlike a mediator or conciliator who don't.
Mr. Murajane, when you were here the last time, you were not the director. Congratulations on the new position.
Thank you very much.
In the 20 years of existence of the CCMA, what are the milestones the CCMA can talk about?
One of the things that I think in all the discussions when we're talking about the success of the CCMA, there's one important component that we miss, and which I want to start and deal with when we talk about milestones. The CCMA, in its success in the past 20 years, it appears from the outside that it is an automated machine. It's not. There are people behind it. The CCMA is led by a governing body, which has the different social partners, business, government, and labor. Below that, you've got an executive management, which represents management issues that integrates and participates together with the governing body. But below that, you have commissioners. You've got case management officers, you've got interpreters, you've got receptionists. So one important milestone, which we must never forget, is that army of people, those honorable men and women, must be recognized and appreciated, because the success that you see of the CCMA, it is because of those persons, or men and women. But other than that, the one important issue to mention is the confidence that the members of the public had and still have on the CCMA. It is not possible for any institution, especially an institution of dispute resolution like the CCMA, to resolve any dispute if the parties that are in conflict do not have confidence in the institution that is expected to resolve its dispute. The other issue is that when you're talking about the Commission or the CCMA, it is not only about resolution of rights. there's issues of interest, there's issues of outreach and training that we do. That is very important as part of the entire package of the CCMA. We have been very proud and did very well in the outreach program that we've done as the Commission, where we go to all corners of the country, we teach people about rights. And that fact is quite important to understand, because the culmination of that education or the outreach program that we do has the product of having cases being referred to the CCMA. If you look at our case statistics, we started at about 64,000 cases referred to the CCMA. But now, as we said, we're sitting with 179,000 cases that has been referred to the Commission. It is not possible to have that high level of referral to the Commission of cases if people do not understand two things. One, that I have certain rights that I have a right to enforce, and two, where do I refer those cases. And in the entire mainstream, there's three major processes that we've run, and successfully so. One, the resolution of the disputes of right. That's your unfair dismissal, unfair labor practice, issues of unfair discrimination, and such like cases. We have been very successful in that area. The second part is facilitating processes such as your job-saving programs, because sometimes when people look at the Commission, they think it's just about people who are fighting about rights and interests, but sometimes it's about those softer issues of saving jobs. For example, in terms of our strategy, which is Senzimetlu, we set that a target of 20%, which means effectively that if you have 1,000 employees facing retrenchment in the large-scale dismissals, we set a target for ourselves and said 20% of that, we must save those jobs. And we have exceeded that to up to 35%. And now we're sitting at almost 40%. That is a contribution into the labor market in terms of stability. And in addition to that, the one that is profiled mostly, which we take pride in as well so much, it is dealing with matters of public interest, your public strikes. I mean, you remember the Marikana case. I can refer to that. You refer to Com strike. You refer to the Pick It Up strikes. We have a list of those cases. I'm just mentioning those because those are the highly profiled ones. But we've got hundreds of those cases that we deal with that are not as profiled as that. The important thing is the following, is that when you have an institution of dispute resolution like the Commission, wherein such trust and confidence is placed, when called upon to resolve such dispute, we've come in and we've resolved those. Despite the fact that, like in the Maragana matter, that you would have had a number of people losing their lives, but in the end, we've managed to resolve the dispute, and thousands of those. We take pride in that, and we're happy. So if you look at the success of the CCMA in the past 20 years, it is that active, using the Minister of Finance words, the active role and participation of the CCMA into the stability of the labor market.
I want to go to Mr. Moloto, but I want one question placed aside here by yourself, Mr. Murajana. What is the jurisdiction of the CCMA?
It is exactly what I've described. I think Patrick dealt with that. It is about two main components. It is about dealing with the rights issue or the dispute of right, and dealing with issues that relates to the dispute of interest. Dispute of interest in the normal course, it is those disputes where parties intend to create new rights, or where there's, like for example, as you mentioned earlier on, people wanting to have a certain amount of a salary paid to them or wages. That will be issues of collective bargaining, which is part of our CCMA jurisdiction. Issues of right is issues like unfair labor practice, unfair dismissals, unfair discrimination cases. It is the part of the entire pot of the CCMA jurisdiction. So we deal with those. We won't deal with other issues such as damages, for example, which is an issue that has to do with the jurisdiction of the labor code. But issues of that nature, which was the whole idea why it was created in the first place, so that it should be quite expeditious, it should be inexpensive, that people should never feel intimidated in thinking that when you come into the Commission, you are coming there and you're coming to a court of law. It should not have that feel. When somebody walks into the doors of the CCMA, you must feel that I have problems, and when I leave this institution, I want to feel better. You're not there because you're a technical expert in law. You're not a technical expert in terms of economics. All you know is that I'm earning 5 rand, I want to earn 10 rand. Can the commissioner facilitate and help me get that? Or I have been dismissed. Can the commission help me to be reinstated or reemployed and be compensated in the process? But coming out though, feeling that the system is very different. So our jurisdiction is on arbitration, mediation, conciliation, and facilitation.
Mr. Moloto, what is the role of unions? I know I read somewhere that the CCMA is, people on the CCMA is formed by NEDLEC. What's NEDLEC's role in the CCMA?
Okay, I think to start with, let's organize labor and workers in general. Salute the CCMA on its 20th anniversary. the CCMA came a long way. You'll remember that before the CCMA was formed, workers were, if treated unfairly or dismissed, they were going through an official of the Department of Labor who will just make a unilateral decision. So we came from there, and it's important to pause at this moment and reflect as to where we were before the CCMA and what have we achieved now by its 20th anniversary. So for that, we salute CCMA.
Thank you.
But we need to go further to reflect specifically on the question. I think a lot of workers' rights and opportunities which are there to exercise them. We had in terms of collective bargaining, in terms of getting the rights which are in the Act, for instance, like rights to go and organize at the employer, rights to free the shop stewards or the worker representative, and to embark on trade union activities. They are all enshrined in the Labour Relations Act. But to exercise those rights, you need to apply some of those to the CCMA, and the Commission then help. But what is more important with regard to the formation, who owns the CCMA? CCMA is owned by the social partners, organized labor, employers, and government. It is true that that tripartite structure is housed at NETLEC, and it's from NETLEC where the appointment is then made into the governance or the governing body of the CCMA.
Now, let me come back to something else, Mr. Mahajan. Probably, Patrick, you can help us here. Even despite the fact that representation of the CCMA does not necessarily need legal representation, employers do use their legal advisors, something they could use to drag a case. Sometimes the employers cannot afford to have a lawyer. They don't belong to a union. Is this still the case?
That is the case. D'Amelia, there is a specific provision in the Labour Relations Act that it says that legal representation, or representation by a legal practitioner, and a legal practitioner is defined as a person who is qualified as a lawyer and has an authentic legal qualification. Such a person cannot, in the ordinary course, represent individuals or collectives in incapacity or misconduct disputes at the CCMA. They can represent in other ones like discrimination, retrenchments, etc. But the idea is to exclude lawyers to try and uncomplicate the process of resolution of disputes by arbitration, by not necessarily introducing legal technicalities and complications and so on. There are bases or rules upon which legal advisors can be admitted by agreement, or the CCMA commissioner, the arbitrator, can make a ruling based on the nature of the case, whether it's complicated, whether there's a public interest involved, etc., can make rulings. But only by exception are they in.
We'll continue our discussion looking at the 20 years of the existence of the CCMA. If you'd like to join us in today's discussion, please call us on 011 714 5497 or 5498. Alternatively, you can tweet us at Recourse or email your thoughts about this program and many others that we're going to have. Write to Recourse at sabc.co.za. Stay with us.
Macro is lending a helping hand with big festive season savings that'll move you. Like the Totem 16-inch or 20-inch Mojo bikes for only $10.99. Save 200 Rand. Or save 200 Rand on the Bounce King 10-foot trampoline, now only $24.99. And zip away on a Zingo X100 electric scooter for $1,999. Save 300 Rand. Share in these and other big festive savings for home, for business, for life. Only at Macro. Big on life.
Did Did you know that Vilakazi Street is the only street in the world to have housed 2 Nobel Prize winners? Vilakazi Street in Orlando West, Soweto, southwest of Johannesburg in the Republic of South Africa, has been home to Nelson Mandela and Archbishop Desmond Tutu. Nelson Mandela's house was a modest family house from 1946 and still maintains those features. Archbishop Desmond Tutu still owns his house in Vilakazi Street since 1975 and often goes to stay there when visiting Johannesburg. Because of its popularity, the street has an influx of tourists. Restaurants with local cuisine have mushroomed around it, creating job opportunities for the locals and improving the lifestyle in the area. Orlando West High School in Vilakazi Street is known for its creative role during the famous 1976 uprising.
Welcome back to Rights and Recourse as we look at the CCMA over the road traversed over the last 20 years. Mr. Murajan, you wanted to expand on the legal representation that Patrick was talking about.
Yes, it's a very important and a very significant right issue that we need to talk about. There's been case law to it where we've been taken to the court, Labour Court, Supreme Court of Appeal, and to the Constitutional Court, where the question of legal representation was at issue. What is important to understand, and in relation to the question that you asked me earlier on the jurisdiction of the CCMA. Firstly, the jurisdiction of the CCMA is determined by the Labour Relations Act. Out of that, in particular, Section 115 gives us the power to create rules on who appears at the CCMA, and we've created that rule. It's called Rule 25. In Rule 25, you will see that the issue of legal representation, while permitted, but it is only permitted under certain circumstances, as Patrick has outlined. For example, on the biggest caseload that we have comes from the cases of unfair dismissal. And on that one specifically, there's no direct entitlement to bring legal representation. There isn't. Also issues of poor work performance, for example. Where the issue of legal representation is not an issue is in other matters such as your unfair labor practice and matters such as your unfair discrimination. Legal representation can be brought there. But even under that one of the unfair dismissal cases, when a party raises an objection on the presence of a legal...
Now that you are on unfair dismissal, can you also touch on constructive dismissal?
Yes. Constructive dismissal is a special element, it's a special product. It's a very interesting one. Actually, how it happens, just to put it simply, if you work like yourself, you work at the SABC, and assuming that you're an employee of the SABC, I know that there may be questions that
something that I don't know.
Now, an issue here is about whether the circumstances or the conditions of employment have been made so intolerable for you as an employee of the CCMA to a point that you cannot put up with it. So the next step, which is an important prerequisite to the constructive dismissal in terms of Section 186, is that you will then decide to resign based on that because you cannot take it anymore. And once you resign, therefore, based on that and the reasons being what I've just explained because of intolerable conditions, then it becomes a constructive dismissal. It is a dismissal that happens as a consequence of conditions which forces you to resign. Once you've done that, then you can refer a case to the Commission of the CCMA. At the CCMA, in terms of Section 192, we are expected to show that, in fact, you have been dismissed. It's one of the difficult things to do because it's not your ordinary dismissals where an employer dismisses you, that here's a notice of termination or here's a disciplinary hearing. This is at the instance of. So when you come there, we have to show that, first, these were the conditions. Based on these conditions, I decided to resign. If the commissioner agrees that the conditions are so bad that to a point that you are unable to cope with it, that the resignation was the only option available to you, then it becomes a constructive dismissal, and it's part of the law of dismissal in general.
Mr. Mloto, despite the fact that the CCMA was established with the intention of providing unbiased solutions to disputes, issues that neither party involved are able to resolve internally, industry still see the CCMA as biased towards the employees.
Yes, to some extent, there are those views. Commenting a bit on the earlier issue of legal representation. labor, organized labor, trade unions are still very unhappy about that. Because who are these employers bringing lawyers against? Against their poor employees, against people who...
In other words, they know their salaries, they know how much they get, they are not going to be able to afford a lawyer.
Exactly. Now it shifts the balance of representation. Now this poor worker has not been trained, he cannot put his case clearly. Now the employer is in a position, because if you allow these people, like you suggested, they can be allowed, you bring an external expertise to come and deal with issues which arise at the shop floor issues. The employer himself cannot go and convince the commission about his own action. Now, therefore, we believe this issue need to be re-looked at on a continuous basis. But even in addition to the lawyers, the employers today are bringing a lot of employer associations, a lot of external forces other than lawyers to represent the employer against poor workers, against people who cannot. Now, it defeats the original intention of the rules of the CCMA, or how the intention of CCMA was to keep things simple, where a worker can simply just walk there and report a case. Now you bring him a lot of other logistics sourced from outside, aimed at keeping this person outside. And you find that even where a worker could be able to articulate this case, a legal guru come and just quote an act, even if he quote wrongfully, he end up winning because the commissioner is also not a complicated
Mr. We'll continue this discussion along. I would like to find a lot of things around this issue. But let's take this call from Nokuthula from Johannesburg. Nokuthula, good afternoon and welcome to Rights and Recourse. Sikhona kunjani Nokuthula?
Ngiyaphila. Ngaxoshwa ngangisebenza kwenye company eSouth Ocean ise-Alvote. And then ngayuwina case namanje angitholi respond ukuthi kwenzakalani. Mangibafonela labantu ababamba icase yami bayabamba bayayeka bangitshela ukuthi kwenzakalani.
Thank you, Nokuthula. Nokuthula says here she was awarded. The company is not carrying the award through. I think there was something around awards in the CCMA last year or the year before. Could you explain that to us? Explain that to Nokuthula.
Nokuthula,
what recourse does she have?
On the information she's making available, it appears that the matter either went to the Bargaining Council or CCMA and an award was issued. If those facts are correct, there's two parts to an award, because I don't know what the award says. There's two parts in the main award. There's one that has to do with specific performance, which is either reinstatement or re-employment. The second part is the monetary portion. Sometimes an award can say you are reinstated with back pay, and back pay is the monetary portion. And if you look at the award gives you the quantum of what needs to be paid. What is expected immediately after the award is made, that the award as issued by the CCMA or bargaining councils must be presented to the employer. You must offer the employer an opportunity to respond to the award. A good employer that agrees with that is expected to say, the CCMA has made an award against me, I participated in this arbitration, the employee must be reinstated and be paid X amount. You do that. That is compliance. But unfortunately, we're not living in that era where people just readily accept that. What then should happen after that is that the employee, once that part is done, you must have that award certified by the CCMA. It's a simple administrative process. Once the award is authenticated or certified, it means it is an award issued by the CCMA and it is valid, final and binding. Once that is done, if an employer refuses to re-employ or reinstate as per the award, now you have to approach the labor court. At the labor court, interestingly, there's a pro bono office that is established there to assist persons who cannot afford legal representation.
I like that word, pro bono.
Yeah, pro bono, Patrick. So, which effectively means that you go to that office and then they can bring an application to court and say, please enforce this award. But the reason why you go to the labor court is it's not about the monetary portion, because that has a different solution. It is about contempt. It means the person who's ordered to reinstate has not reinstated. That is contempt of that particular award, because that award is equivalent to a court order. So two things might happen out of contempt, which I am still pressing that it must be done. That if you have no basis, there's no review against an award, but to refuse to re-employ, to reinstate, you must either, through the finding of the labor court, be made to pay a fine or be arrested and put in prison, because that's contempt of court. That's the teeth that the awardee should have. Because what is the point in us as the Commission and the Bargaining Council of going through the entire process of setting the case down with all expenses that are occasioned with it, and then a poor employee who sees, I am entitled to 100,000, I'm entitled to go back to work, but they cannot enforce it, then it's pointless. So that's the portion. The other portion which is interesting.
That's actually the question I was asking when I asked about the jurisdiction of the CCMA.
Yes.
How far can it go
from our
to
side,
have these awards? To have the awards implemented.
The one interesting part which I must introduce, which I want to announce so that the vulnerable employees who are earning below 205,000 per annum should note, is that if you have a monetary award where they say, for example, there's a compensation, one of the gravest challenges and offense to social justice is when somebody has a monetary award that cannot be implemented, because when they go to the sheriff to implement, they tell them to pay a certain amount. How does an employee who has no money, who has been out of employment for a certain period of time, go to the sheriff and pay a deposit and security amount of 10,000 plus? It's just not practical. It affects the very award we're talking about. What we've then designed together with the Department of Labor is a fund. That fund is intended to assist those vulnerable employees in the execution of the award. That is within our jurisdiction. In fact, there's a court case, MBS judgment, that has given us that power. It's important that it be noted that it said the CCMA can issue a writ of execution. That power we have, that power we're exercising, that if you come to the Commission, don't worry about the cost if you are below the threshold, come to the Commission and say, here's an award, he refuses to implement. We pay the sheriff cost, we recover those costs from the respondent who's supposed to have implemented, and then we implement on the basis of that. That is our jurisdiction.
Noktula, if you can check our email address, you can send your problem to us. We'll pass it on to Mr. Murajane. If your issue has not been solved, you can do that. Use our rights and recourse at sabc.co.za. Send it to us. We'll pass it on to Mr. Murajane. The other problem is, why is this process of getting resolution, Mr. Narius Maloto, to problems between employer and employee so adversarial?
Look, number of factors.
If all of you are sitting at NEDLEC, all of a sudden now there's a dispute, it's become so adversarial, people are fighting.
Yes. Look, we have made progress in the labor relation arena over a period of time in this country. But at the same time, the labor market, the relationship between employer and employees has also deteriorated, particularly when most of companies outsource their HRs. You are dealing with a person you don't know. He's not employed by the company on day-to-day basis. He just comes here and because it's called by the company, there's a problem and there's a bad relationship. Now, most of the non-maturing relations between employer and employees is basically poisoned from outside. But you also have these employers who are going around the world globe and try to copy what is happening internationally and try to impose it on, and this leads to the adversarial relationship, don't care attitude, and also the lack of internal procedures. If there internally there's no process of consultation where the parties meet from time to time on monthly, quarterly basis to review and look into the issues of relationship, the issues of what's happening in productivity and what can be done. People are just being used like their objects, and that leads to resistance. The resistance sometimes reach a boiling point, and the adversariality, I think, begin there.
Let's take this call from Emmanuel from Johannesburg. Emmanuel, good afternoon and welcome to Rights and Recourse.
Hi, how are you?
Fine, thanks. How are you?
I'm fine. I'd like to ask a question. As a bargaining council have jurisdiction on the employees in the agreement with the employer.
Can you speak louder, or can you repeat that question? We didn't hear it because you broke up.
I want to know if the bargaining council is having jurisdiction on the employee whose employer and the union don't have recognition agreement.
Oh, thank you. I hear that question. The question that that I actually asked earlier when we were off air, where a bargaining council takes a decision. Let's take an example. NUMSA gets into a deal with CIFSA, with the bargaining council there. And the small business people say, we can't afford what these guys have agreed on. Or a union is a junior partner in the workplace. The case was AMCU and NUMSA and NUM, where the NUM made an agreement with the platinum mines, and then the platinum mines then said, the bargaining council said, NUM will have to fall by that decision too. And NUM said, no, we can't. We have to negotiate.
The bargaining council agreements, if extended to non-parties, they are binding to all employers in the industry. There's no question about that. That's very clear. But there are these bargaining forums, which are not necessarily bargaining councils. And the issue you just referred to, like the NAM-MAMCU, I think it's a bargaining forum, it's not a bargaining council. So that is a different issue. And in that case, I think there are still complications. It's once again balance of forces on the ground.
Well, yes, if you'd like to join us in today's discussion, you can still call us on 714-5497 or 5498, or you can tweet us at Rights and Recourse, or send us an email like Noktula, or we can answer your question and pass them through to the CCMA if we can't answer them. Please stay with us.
Now this is Trends, of course, your one-stop serving of all that's juicy and trending in the world of entertainment and showbiz. My name, of course, is Refiel Wemwilo.
I'm Dr. Sello Mutaung, and this is our talk.
A very good morning and welcome to Media Monitor. I'm your host, Alicia Jolly.
My name is Dumile Matez.
My name is Mpo Sedu. What time is it? It's question time.
For your daily dose of current affairs, tune in to the SABC News Channel.
Did you know that Vilakazi Street is the only street in the world to have housed two Nobel Prize winners? Vilakazi Street in Orlando West, Soweto, southwest of Johannesburg in the Republic of South Africa, has been home to Nelson Mandela and Archbishop Desmond Tutu. Nelson Mandela's house was a modest family house from 1946 and still maintains those features. Archbishop Desmond Tutu still owns his house in Vilakazi Street since 1975 and often goes to stay there when visiting Johannesburg. Because of its popularity, the street has an influx of tourists. Restaurants with local cuisine have mushroomed around it, creating job opportunities for the locals and improving the lifestyle in the area. Orlando West High School in Vilakazi Street is known for its creative role during the famous 1976 uprising.
Welcome back to Rights and Recourse as we discuss the CCMA, 20 years in existence. Many of these organizations are celebrating 20 years. CCMA is one of them. Let's take this call from Sbonelo from KwaZulu-Natal. Sbonelo, good afternoon and welcome to Rights and Recourse. Hello, Sbonelo.
Yebo, njani?
Sikhona kunjani?
Ngiyaphila. Igama lami nguSibonelo Manjaweni from KwaZulu-Natal. Umbuzo wami engizobuza, ngicela ukubuza ukuthi ngingakwazi ukujoyina i-trade union ngiphinde futhi ngibe nommeli. Ummeli kuzofanele ngimkhokhele naye yini inyanga nenyanga njenge-trade union. If ukufika kuma-negotiation, for example, siya kwi-wage agreement, ama-trade union angafike ezivumelaneni nommeli ngabe kwenziwa njani lapho ke ekugcineni ukufinalize ama-trade union noma i-CCMA noma i-bargaining council nobani okuyibona abagcina befike ku-final decision ukuthi sizothola i-increase ye-percent elingakanani. Ngiyabonga.
Thank you. Sibonelo there needs to know, he says, he doesn't trust the trade unions. He says, can I join a trade union and have a lawyer at the same time, so that when I want to fight my case, I fight my case alone for myself?
Yes, we will always encourage workers in this country to join trade unions, because the trade unions don't represent you only when you are expelled, you are dismissed. Now, a lawyer normally will come in only at the final end, you are out. But the union will handle your grievance, union will represent you during disciplinary hearing, union will negotiate for you, it will do a lot of other things, it will improve things while you are working. So while the lawyer is waiting for at the end, when everything is there, and the chances of really gaining the benefits of joining the trade unions are unlimited. Now we would, and also the rights that are enshrined in both our Constitution and our Labour Relations Act, they can better be realized by when you are a member of the trade union, you act collectively. And the joining the union is not just an individual, it's also a collective. It changed the employment relations into a collective nature from an individual nature, and that is very important.
Patrick, there's something I wanted to know from you. You can probably recollect all the other things you wanted to say and say them at the same time, but there are two things I wanted to find out. There is something new in the industry, in generally the independent contractor and the fixed term contract. What is the difference between these two, and how can I derive benefit from any of the two contracts?
Well, an independent contractor and a fixed term contractor are different in the sense that an independent contractor is not supposed to be an employee. It is supposed to be, as the name suggests, independent. And so it's a person who's providing a service to the client.
To whatever industry.
So it's not an employer-employee relationship, it's a service provider-client relationship. That's what an independent contractor is supposed to be, not only in terms of the contract, but actually that's what it is, no matter what the contract says. A fixed-term contract employee is one who is in fact an employee and enjoys the benefits of labour law that any other employee would enjoy during the term of that fixed term, be it 3 years or 3 months. The independent contractor doesn't have the same access to labour laws because it's a civil contract as opposed to a labour law contract. So that's the essential difference, and there are a whole lot of tests to determine which is which, and it's based on whether it is genuine independent or whether it is genuine employee.
I don't want to cite a contract, but I just want to make the point. It would seem to me there are many of these contracts, Mr. Mahajani, that are actually fixed-term contracts. They are implemented as fixed-term contract, but they have a title saying independent contractor.
What sparks this debate? It's a matter of law, bolstered by facts. What really causes this discussion to even exist is one important thing that we must never forget. It is the element of abuse. Because in a utopian situation, you would have a pure, fixed-term contract that is based on three things. So there's a project to be done, or there's a time aligned to it. There's a factual position that creates, or the nature of the contract creates the relationship to be fixed. Let me give a practical example. So if you have a cleaner, or you have a receptionist, so if you fix that contract, what exactly are you doing? Because receptioning is a function that you always need. Cleaning is a function that you always need. So the key factor is that, is the job fixed supposed to be fixed? Because that's the interesting test you must apply. You see, the amendment of the 2014-2015 has brought that issue up and said there are three main non-standard employment that exist. It is the one that deals with the labor broker, two is the fixed term, the third one is the part-time. So, but when it comes, the SABC interestingly has a very precedent case when it comes to issues of who becomes independent, who becomes an employee in the SABC.
Maybe sit up and take note.
In the SABC versus McKenzie judgment. In fact, the outcome of that was that you look at the dominant impression test. That's what they called. So you look at totality of a number of certain factors. For example, if your contract is terminated today, who's going to discipline you? Or if they terminate it, who's disciplining you? Is it an agency or is it the SAB as an employer? Sometimes we get lost in the facts. You look at the contract, you read what the contract tells you, then you decide that's what the status is. It's not correct. The contract is but one factor you take into account in determining on whether a person is an employee or not. So if you are a person and you are called an independent contractor, it's not about what you're called. It is about what you do, what are you entitled to, where's the power of control, where's the power of discipline. All those factors taken into account determines on who becomes an independent contractor. And an independent contractor, Patrick says, is not an employee. A fixed term contract happens both you can have a fixed term contracts with persons who are independent contractors, because being an independent contractor, you are still a contractor, but it's a contractor who's not an employee. An employee can also be a contractor. You can be contractor for a period of 5 years, 10 years, 20 years, 30 years. The trick always comes in whether in that fixed term contract, what rights do you have, what benefits do you have. If you are an employee as defined, therefore there are certain things that are automatically inherent in being an employee. So that is in the main the difference between the two. But there's nothing wrong in an ideal world to have a fixed term contract if it's done purely and honestly. What is wrong is having a fixed term contract that is abusing the rights of employees that should be enjoying by virtue of being an employee. For example, issues of medical aid, issues of leave, and issues of maternity, issues of, all of those benefits. So if
I just want to go back to something you mentioned earlier, the McKenzie judgment, where you said I think the McKenzie judgment, you ruled in favor of McKenzie. Shouldn't that be a precedent then for all other contracts around the issue of McKenzie, who are also contracts that are structured like that one of McKenzie?
In fact, since that judgment on the approach and the test used, it is that judgment. Because they set a very clear precedent on what you really look at to get what was called the dominant impression. So if you look at the total number of all these factors, what impression does it give you? Is it an independent contractor or is it an independent contractor impression? If the impression out of all those factors carefully considered gives a dominant impression that the person is an employee, then the finding is he's an employee. That's the bottom line. So that case has in fact set that precedent.
And if I could also add to that, the Labour Relations Act sets out in great detail basically a checklist about to measure the dominant impression test, to determine whether this person is in fact independent or is in fact an employee. And the contract itself is only looked at as a first level. What is happening in practice is really the test. Is it genuine or not?
And in labour, we also have similar cases that we have been witnessing, where an employer come and make almost all his employees independent contractors, and he keep on using them through and through. So it's an utter abuse of the system.
I thought the issue you are raising is something I wanted to test with Mr. Murajan around the Amendment Act that came into effect in January the 15th. 2015. Can you explain that? Because we still see one of the problems that's happened with many organizations is that they will give their employees start at the contract over 3 months, they renew the contract after 3 months, they renew the contract after every 3 months. I said it doesn't matter whether they renew the contract after every 3 months, those persons should be regarded as full-time employees, especially if you want them there every day.
Yeah. Well, that's a really powerful innovation that came into these new provisions of 198. And basically what they're saying, as Cameron was saying, they're there to protect vulnerable workers, those who come into short-term contracts and they're in and out and then they're swapped with others and they get changed from one another to in a way disguise the fact that they are real employees, and as a consequence the employer is less bound by labour laws and all of the financial aspects that go with it. And so the idea is it's kept at those employees who earn below the basic conditions of employment minimum, which is 205,000 Rand a year, because those are considered the vulnerable employees. And I think there's general acceptance that there has been a lot of abuse around the use of short-term contracts and in and out and so on. So there's no security of employment is the bottom line.
Let's take this call from Thomas from the Northwest. Thomas, good afternoon and welcome to Rights and Recourse.
Afternoon, how are you?
Fine, thanks. How are you, Thomas?
I'm good. I just want to find out, because I got a writ of execution back in 2014. I was awarded by the CCMA. And then because I couldn't afford the processes of the sheriff and everything, I approached the legal aid to assist me. Now, legal aid hasn't assisted me so far, so I'm not sure whether should I go back to the CCMA or what should I do to get an assistance. And I'm not sure whether the award that I had, is it having some time frames to expire after how many years, or does it stand until I get justice?
You can answer that question.
Let's respond directly. On the assumption that he ends below the threshold, he must come to the commission. The legal aid won't take it any further, because he's got an award, he's got the writ of execution, is what I explained earlier on. What he has now is what effectively sounds like a monetary issue because it's gone to the sheriff. He must come to the commission, and then he will be gladly assisted, because we have the power now to execute that award. He cannot sit there and waiting, and it is not going to take him any further. He must come to the commission, and we'll check if the award has been authenticated. It's a valid award. If it's authenticated and the warrant of execution has been issued, it just needs to go to the sheriff. We will definitely deal with it immediately when he brings it. He doesn't need to go anywhere else. He must come to the commission.
There you are, Thomas. Mr. Mrojan, the other question I wanted to ask, if the Mackenzie ruling was a precedent for all other rulings around wherever Mackenzie came from, why is the CCMA, can't the CCMA not then, if there are 3 or 4 cases coming from the same organization, and say, we need to go and investigate what is going on there?
It's a jurisdictional issue to me. I wish we could have more teeth and strength.
That's why earlier I asked, what is the jurisdiction?
Yeah, the jurisdictional issue. Let me just explain it. You see, if you have an employee who is aggrieved about an outstanding pay, if that is just the only issue that he has, it's not within the jurisdiction of the CCMA. It must go to the Department of Labour. But if your outstanding pay is attached to an unfair dismissal case, you are able to do so in terms of Section 1774, I think, of the basic conditions, where your case is seen together, your outstanding pay, including your unfair dismissal issue. But when we see that there's a problem in certain institutions, because our case management system is able to show the referral rate and which sector you get more referrals. As a result of that, we've designed programs. For example, the Building Workplace program, or Building Workplace Relations, the PWR, where we as Commission, we're doing that in Parliament at the moment, where there's a breakdown in relationship which brings into more than one dispute. And sometimes you see just one set of facts that leads to different types of disputes. It shows that there's something wrong in the system. So we do make an offer, but we do not have the power to impose that we see there's a problem, so we're coming in as if we're sheriffs. No. We offer that to the employer and other social partners in the workplace and said, look, we can see that there's issues relating to relations here because of the trend and the issues relating to the dispute that arise here. Can we come and assist? Then we deploy our commissioners to go and do that big building process of workplace relations. We do have other programs such as the workplace mediation as well, where we see that there's a conflict there of whatever nature. We are able to deploy commissioners to go and mediate at the workplace. Before
you mentioned earlier that you were involved in Marikana, you were involved in the Pick It Up strike, you were involved in many others. This is a new thing that you go in so that you lessen the damage.
Yes, and over and above that, we have what we call a Section 150 intervention. If we see there's a strike going on and we may not have been involved from the beginning, we then are able, in terms of the Act as it stands, in terms of the amendment, where we can intervene and say, this has gone this far, this is the damage caused, we think we can assist. One important factor that I must always mention, the power to resolve a public interest matter lies with the parties. Because if the parties decide not to resolve, there's nothing that we can do. I know there are new innovations now in terms of the legislative amendment that deals with the protected strike, the violent strikes, and things like that. And I think it's almost done and completed, which will contribute in assisting that. But as far as the system is concerned, we do have that power of intervention, but we do not impose as such, because even if we have the power as we have, we say this strike has gone for too long, we're coming in, we're going to resolve this thing. If parties come in there, they sit and keep quiet, what are you going to do? There's nothing going to do. You have to get the buy-in from the parties themselves.
Let's take this call from Zwandile from the Eastern Cape. Zwandile, good afternoon and welcome to Rights and Recourse.
Good afternoon, sir. I've actually got 3 points. The first one is, look, I'm very concerned. I'm in the Eastern Cape, and CCMA is greatly misrepresented geographically. So I want to know, how are they going to go about having offices that are able to service communities that are far from the cities? I'm talking more rural communities now, which might not have money to travel daily to the larger centers to lodge their cases. And the second point is, I would have thought that the Fees Must Fall campaign would have actually been one of the areas where the CCMA would have been able to stamp its authority in representing both the universities as well as the grievances from the pupils there. Now, I'm not sure that process is over, so I'd like to know how they see their involvement there in assisting what we are now experiencing. And the last point is, when it comes to the unions, I would have thought that unions by now would have been able to amass a lot of capital to be able to buy shares in some of these mines, which allows them to have some form of representation in those boardrooms. So I'd like to know from the gentleman there that comes from the unions, if that is not a strategy that would also assist to build greater resources as well as representations by themselves in those mines or in any company that offers shares on the JSE for them to have bargaining power, if that be. Thank you very much, sir.
Thank you. I think there's a caveat in that question about unions buying into mines, and many unions own a lot of businesses, and we've seen problems within those businesses of the unions. Probably we should start with you, Mr. Moloto. Answer that part, the last part of that question.
No, already most of these companies are owned. The bigger shareholders are the retirement fund of the workers. Now, workers are there. It's just that they are not there direct, they are there indirect. And the unions have in the past formed some investment companies, although they've created some problems. But I agree with the caller that that might be one of the ways to influence the policy and to make sure that all the exploitative conditions that are there, including the improvement, are tackled at the board level. So that is a positive contribution, and I think we can take it forward.
So probably we close this discussion with a response from Mr. Marajan around the issue of rural offices, accessibility. Yes.
Mzondile, I'm very happy you asked that question, because it is a gospel I'm preaching everywhere I go since I started in every region. Accessibility is the big issue. And I said earlier on, what is the point in having a good dispute but you don't have a place to refer it, or you can't afford to refer it? What we've done, we do have offices in every province. We do. Like in Gauteng, we've got 3 offices. Now, what we've done in order to bolster that, we are now using the offices of the Department of Labor for people to go there and still find the CCMA there. But one innovation which I'm still pushing very hard, especially when it talks about the Eastern Cape, you're talking about Limpopo, for example, where you have, like in the Northern Cape as well, because some commissioners have to travel per day 800 kilometers to go to cases, depending on the number of cases. But the innovation that we've now come up with, which we're trying to take off the ground, is to have mobile trucks. In the mobile truck, you should have a commissioner there, a case management officer, and an interpreter. And hopefully also have a Department of Labor there. So that when those that are in the rural areas, those are in the far-flung areas, are able to come to the truck and say, I've got a case. So they can fill in the referral form, they can get the status of their cases, they can get their award there. If it's about unpaid wages, they can then deal with the Department of Labor.
By the way, should commissioners be lawyers? Should they have a law background?
Not necessarily. Let me give an example. That's a very interesting question, because we get that from time to time. The Act says that you must deal with the cases in the Commission with less legal formalities. So if you load lawyers, you are going to do exactly the opposite. But I'm not saying at all times that lawyers do that, because we do have commissioners who are practicing advocates, who are practicing attorneys, who've got a bigger experience in terms of HR. It is not a prerequisite to have a law degree, but The rider to that is that, like Mr. Mulota said earlier, if I have a matter that has to do with job saving or that has to do with a strike on wages or terms and conditions of employment, issues that are involved are socio-economic issues. So you do not need a legal brain to resolve that. You need somebody who understands the dynamics and all the issues that are constituent into the labor market. The legal issue comes more into a situation where you have a dispute of right, like in the arbitration, because you've got the law of evidence, there's statutory interpretation, there's case law to be read. But it is not a prerequisite to be a lawyer, to be a commissioner. But you must have sufficient experience in terms of industrial relations, HR, and a large degree of a legal education, because we teach that for
let's give
commissioners
the
when they
final
become
minute of
commissioners.
the show to a lawyer, Patrick Deal.
Thank you, Demilia. Look, the difference between the CCMA and a court is that the CCMA is a tribunal. It's an administrative tribunal that makes decisions in accordance with a framework of rules, which we know as labor law. And so it's true that you don't need a legal degree to be able to do it, because it's based on the principles of fairness, of equity, as opposed to legality. That's the difference between a court and a tribunal. And so, but actually, lawyers can make a major contribution, because the process of CCMAs have become, in fact, very, very legalized and legalistic, as Cameron indicated earlier. So lawyers can play a constructive role, provided they play a constructive role rather than a frustrating role. I think they can make a serious contribution.
Gentlemen, thank you very much for your time. It's been a very fascinating discussion. I think a lot more people have they heard the questions coming from Noktula, which we're going to follow up with Mr. Murajan, and anybody else who has other questions, you can always send your questions to us. We'll pass them on to Mr. Murajan. During the 15th anniversary of the CCMA, the director of the CCMA wrote this piece, and I quote, "The CCMA has become a well-known and well-respected institution, and we see that it is very important that it plays its role, or an expanded role, to our social partners. It must lead the way in facilitating processes in which organized business and labor, and perhaps too the state, can shape their contributions to the labor market. It is significant that while preparing for this, my brother who lives in the United States telephoned me for advice. His boss had via email sent his PA of several years standing an email of firing her. She had packed up and left before he got to his place of work in the morning. I'm so glad that in South Africa we have a recourse in relation to arbitrary behavior by anyone in the workplace, and that the CCMA exists to support labor and business in ensuring that fair conduct in our society. We have our challenges, but the cornerstone of our democracy is the right to complain. The CCMA represents a fragment of those rights." This program is repeated at 5 on Wednesday morning. From all of us in the studio, good afternoon.